care is understanding a fiduciary's role on a public retirement system board. As Michelle's coming up here, we'll get a round of applause for her in just a second here, but she spent nearly 15 years at Texas Municipal Retirement System before moving into your current role, correct?
Right.
Yes, and she also told me last night when we went to the Devil's River, she's like, the stuff that I can help these people with is what they really need help. This is not securities litigation, correct, is what you told me last night.
That's right.
This is the stuff that they need help with. So that's what we're going to talk about in this presentation, correct?
That's right.
All right, let's flip that mic on.
Is this working?
There you go.
Oh, there we go.
You are
Yes.
ready to go. Let me get you a clicker, and you are all set. Please help me welcome Michelle to the stage.
Well, good morning. It doesn't seem like morning in here. It seems a little dark, but I hope you're all awake. I hope you've had plenty of coffee. So this morning, let me see. I'm going to jump through. We're going to talk about all things fiduciary duty. And I am going to talk about what is a fiduciary, who is a fiduciary, and fiduciary duties. But before we get into that, I want to briefly show you the legal framework for fiduciary duties. And that includes our Texas Constitution. So in the Texas Constitution, you have the genesis of fiduciary duties. And it's also in various parts of our state law. For some of you, it can be in ordinances, and it is in your plan document. Now, I asked the advanced fiduciary training on Sunday if they knew where their plan document was or if they had a copy. And these were all trustees, and I think we had 2 people raise their hand. So my homework for all of you is to make sure that you have a copy of your plan document. And for a lot of you, that would be in Vernon Civil Statutes, section 6243, the various subsections along there. But you should have a copy of that. Not just because you do need to know and have sort of the description of the plan benefits, and statutes are not written for comprehension, they're not easy, but there will also be a section about your board duties and sort of what you are responsible for. So that's extremely important, so I want you all to make sure you get a copy of that. There's also ERISA, which is federal law, which is instructive. There's a lot of case law interpreting fiduciary duties for ERISA, which is for private plans, but you all should understand a little bit of them because oftentimes courts will look to those for a deeper explanation. And then in the Internal Revenue Code, all of you are qualified plans under section 401A, and there are regulations that require that you behave in certain ways. There are prohibited transactions, and then we'll get into sort of all the different fiduciary duties. So next I'm going to talk about what is a fiduciary. So a fiduciary is basically someone who has discretionary authority or control over the assets or management of a fund. You're taking care of other people's money. So that's what it means to be a fiduciary. Basically that you have control and discretion. So whether that's discretion in the administration of the benefits or in the investment of the assets, you are a fiduciary if you have that control. So who is a fiduciary? If you are sitting in this room and your title is trustee, and that's why you're here, you are a fiduciary. Congratulations. And you're in the right place, because this is fiduciary training, and everyone should have it. So if you're a fiduciary, if you're a trustee, you are a fiduciary. In your plan document, there will also be named fiduciaries. And that's important for you to know who in your organization is a fiduciary as well. So generally, that's sort of your executives, if you have them. That is who will be also fiduciaries in your system. There's also a functional definition. So the courts will not just say, okay, that person isn't named in the document, so they're not a fiduciary. Anyone who exercises control or discretionary authority over the plan assets or the administration of the fund will be considered a fiduciary. So the ministerial functions, sort of the basic processing of benefits day in, day out, that's not considered a fiduciary. if they're just making sure that the benefits are being paid, things like that, that payroll's going out, that everything is, moving along in the system, that is not fiduciary. But anyone who decides on trickier, like disability benefits, things like that, generally that's left to the board, to you, right? It comes up to you if there's ever a question. That's because you're fiduciaries and you're making that discretionary authority. So now we're going to jump into fiduciary obligations, and I'm going to dive right in because we don't have a huge amount of time. So I'm going to start with the duty of loyalty. And this is, to me, the only fiduciary duty, honestly. If you follow this duty in all things that you do, you will be following your fiduciary duties. You will be acting as a fiduciary. So under the Texas Constitution, like I said, that's the underlying premise for us here in Texas. Funds are held in trust for the benefit of members. That's a quote from the Texas Constitution. I have to say that yesterday, for those of you who were here for the fireside chat and heard the domestic dispute that was going on up here, you were also lucky enough to get a master class in fiduciary duty of loyalty. I was blown away. I was so impressed. Henry, Tyler, Ben, Paul, and Colby, you all have graduated. They were amazing. They talked about leading from your heart. And that is exactly what the duty of loyalty means. You are acting always in the best interest of the members and beneficiaries. Now, for most of you in here, if you're in the plan, trustees are in the plan, they get it. Where we get into a little more trouble sometimes is when people are not in the plan and maybe they don't know as much about the plan and the benefits and the importance to the retirees and the members who have worked hard and provided service their entire career. And that's why we have regulations. As you can see, this is the IRS regulation that requires that the assets be used for no purpose other than the exclusive benefit of their employees. That's the underlying rule. This is also what determines the one hat rule. And I think during lunch yesterday, Tyler mentioned it when he said, when you walk into the boardroom, no matter who appointed you, no matter who elected you, no matter who your constituency is that got you to that board position, you take off all those other hats and you make decisions based on what is best for the system as a whole, right? So you're gonna make sure you're making sure that benefits are being paid, you have liquidity, right? So everything you do wraps up into that duty of loyalty. You're gonna make sure that you have enough funds to pay ongoing benefits for the future. So you're gonna be looking ahead. You're gonna be paying attention to the administration of the benefits. How is it happening? If you have turnover, are people being trained so that they understand what's happening? So everything you do is informed by this duty of loyalty. It is truly the key. And all the other duties that I'm going to go through are really just a way to explain sort of the nuances in different situations of how you implement this duty of loyalty. So I will say, if you understand this and you always follow your heart when you're acting as a fiduciary, you will likely not go wrong. So next we have a short slide on what not to do. And honestly, this is also informed by the duty of loyalty. No self-dealing, right? Don't pay higher fees than what you should be paying for service providers, asset managers, investment managers. Do not use assets unwisely. Don't use them for, anything that might not be for the benefit of members and retirees. So basically, that's sort of the underlying theme of what not to do, and that goes into what the Department of Labor and the IRS has also said for prohibited transactions. So they're all based on not using funds for anything other than the benefit of the members and retirees. So when we talk about the duty of care, this is one of the other duties It's to act as a prudent person with experience in a similar enterprise. So what does that mean? So as you can see, this is taken from the Texas Constitution. So we break it down and we look at, first, we exercise judgment and care. That means you understand and you pay attention. You read the materials that your experts that you've hired have given you. You try to understand everything that they're telling you. You're here at this conference learning about all the different investment structures and vehicles. You're learning about fiduciary duty. You're learning about how to bring in new trustees. You're learning about how to be the best trustee you can and govern the trust fund. So this is going to be number 2. It says, under the circumstances then prevailing. What does that mean? That means that you have to pay attention to what's happening around you. You don't have to have a crystal ball into the future. If the investments don't work out, that's not part of what fiduciary duty means. But you do have to pay attention to what is happening right now. You do have to understand what's going on around you. You have to understand your plan. Every single plan is different. You have different, right? You have different average age of your members, your retiree size compared to your current employees. You have different parameters for every single fund. And that will instruct how you make your decisions. And so you need to be aware of that. So then it talks about ordinary prudence, discretion, and intelligence in the management of your own affairs. So you would act as if you were managing your own affairs, but you're taking into account, you're paying attention, but you're taking into account that this is a situation of the fund. So you're paying attention just as you would for your own finances. When you're taking care of your own finances and you're looking, you're a person of ordinary prudence, discretion, and intelligence, exercising the management of your own affairs, well, you're taking into account, do you have kids? How much does it cost? Are you sending them are they going to after school, sports programs? How much does that cost? Are you planning to send them further education? You're planning for all of that in your own life. And so when you're managing the fund, you have to pay attention to all of the parameters, all of the factors that you need to consider. And then this last part, it talks about in regard to the permanent disposition of your funds, considering probable income as well as probable safety of their capital. Do you know what that means? Risk and return, right? So that you're taking the correct amount of risk for the return that you're receiving. So you're not being too risky and you're not being too cautious, but you're taking the right blend to make sure that you have liquidity to pay current benefits and that you can plan for the future, right? You've got your funding policy, like the PRB was talking about, and you're planning ahead so that you can pay out those benefits long term. Skip that one. So it also, as I said, it applies to both administration and investments. And it creates some affirmative obligations, as I mentioned. You have to participate. You need to read your materials and pay attention and make sure you understand them. There's no dumb questions in a board meeting. You always want to ask whoever your consultants are, whoever is helping you, whether it's staff or service providers that you've hired to assist you, who have expertise, then you need to ask those questions and make sure you understand. You also need to use reasonable care because there is co-trustee liability. So you want to make sure that you're being aware of what other trustees and how they're acting. And if you see someone acting out of line and perhaps breaching fiduciary duty, you need to make sure that they understand their fiduciary duty. I can tell you 9 times out of 10, it is a lack of understanding. I can't say it's 10 out of 10 because we always know there's somebody who's going to act differently, but 9 times out of 10, it's an education issue. You need to make sure people understand their fiduciary duties. Nobody wants to be liable for fiduciary breach. Nobody wants that. It's not, it wouldn't be pleasant. There's a lot of headline risk. You also need to seriously evaluate investment proposals. And then we're going to talk a little bit about delegation. because that is a huge part of being a trustee. You all are not expected to run the plan and do all of the underlying factors. So proper delegation really takes a certain duty of care, and it's not that complicated when you break it down. Really, you want to select an appropriate delegate with experience. What does that mean? That means you're going to make sure these people, whoever you're hiring, has the expertise that you need. You're going to look at their credentials. You may have internal staff that have the expertise. You may want to educate internal staff so they have certain expertise. But you also will be hiring, guaranteed you'll be hiring outside experts to help you, investment counsel, if you need actuarial assistance, that you will definitely be hiring. So you need to ensure they have adequate information and resources. Make sure they know everything they need to know in order to give you the right answers and the information and their opinion. You're going to impose certain duties of care and loyalty on those delegates. And periodically, you're going to make sure you go out for evaluation to make sure that you're getting the best services you can for the right fee. And these things will change over time. And I'm including things like technology in here, because you may want to hire consultants. That's one of the biggest risk factors these days, is the technology risks, right? Cybersecurity and protection of data. And I didn't skip it, but duty to monitor. That's an underlying duty. Once you've delegated, you have an ongoing duty to monitor. The Supreme Court has actually taken this up for ERISA, and it is one of the duties that trustees have. It is great, and I think up here on the panel earlier, they were saying it's fine when you finally pick an investment, but you also have to continuously monitor them because things change, and you want to make sure that you're keeping track of that. As I mentioned, I think I've gone through most of this. Decision-making for investment decisions. The one factor I would say is your process is going to be extremely important. And if you do not document that you have gone through the process, then I will argue as a lawyer it did not happen. We can't prove it happened if you don't document it. So whether you have your experts, investments, consultants, come in and give you presentations, make sure they give you documents on why they're recommending who they're, whatever investments it is, and why this is the best option for your fund. When you're doing an RFP, you want to make sure you're getting the qualifications so you can make a well-informed decision. And all of that needs to be documented. In your minutes, you want to make sure it says that you deliberated, that the board considered and deliberated, that you considered certain factors, and have those in your minutes. You don't have to say who said what, but just make sure that you document that you all deliberated and considered these issues. That is your document proving you did your fiduciary duty. And I know you all did, so make sure that you document it. Because one of the typical things that we do is we have all these processes and policies that we act on. We do the right thing, but we don't always document it. And it's very hard to prove if you don't document it. Have it written. And policies are the same way. Have written policies. Because even though your people are doing the right thing, if there's not written policy that this is what they should be doing, someone could argue that's not the way that's always been done, and they could argue that it's not being done correctly. All right, duty to diversify to maximize risk-adjusted return. So I've put the TELFRA definition here, which says, for the TELFRA systems, it says to emphasize safety and diversity as well as liquidity for benefit payments. There's other sections in Verdens that say that they're not in regard to speculation, but in regard to probable income from the assets as well as the probable safety of their capital, much like what's in the Constitution. So it's always about risk versus reward, which I know you've heard a lot about this past day and a half. So you always want to follow your investment policies and your asset allocations. You want to look the entire portfolio. is what will show that you are doing your fiduciary duty. So one bad investment is not problematic unless you've overweighted and you haven't been considerate in making sure that you're getting the correct risk to return. So you always want to make sure that you're balancing that asset allocation, because that is incredibly important. It's one of the most important decisions boards can make. So it depends on the facts and circumstances, right? Depends on what the situation is of your fund. What's your, what is your funding ratio? How is it moving? What is your, your profile for your employees and your retirees? And there is always this caveat that says, unless under the circumstances it's clearly prudent not to do so. And that's a very rare occurrence, and I can explain that to anyone if you're interested, if you're curious. But there's also a duty to follow your governing documents. And again, I mentioned about how important your plan document is. I can't tell you how many plans, pretty much every plan, has some small piece that they are not doing, that has fallen by the wayside, that they have forgotten about, that their staff is too busy. There are IRS regulations that are sometimes extremely difficult, and when staff gets busy, it falls by the wayside. And there's some things that have to be done annually that maybe someone didn't get trained on, you have someone new, and they just fall by the wayside. But these are important, and you need someone to be coming through and checking to make sure that you're following your plan document and you're in compliance with all of the rules and regulations that are required. There are ways to do corrections. I mean, IRS has a correction procedure that is gotten very, very simple. They've made it so much easier for plans to correct. And the basic guidelines and underlying premise of the correction process is to put the plan back in the place where it would have been had your error not occurred, and to put your members back in the place they would have been had the error not occurred. That's sort of the guiding principles of the corrections. And so it's generally not too painful to do corrections. So don't be scared about trying to go and look under the cover and find those mistakes. Everyone has them. And they just need to be corrected so that you're in compliance with your plan document, because that's fiduciary responsibility, and with the IRS regulations and other regulations that may be out there. All right, so there's also a duty to avoid prohibited transactions. As I said, overarching rationale for all the prohibited transactions that are listed in the Internal Revenue Code are to act in the best interest of your members and beneficiaries, right? So there are potential penalties. I would say I don't know of any public plan that has ever been unqualified by the IRS, but there are potential for fines, and that's a shame, right, to send money and to use that money for fines. And there's also, Texas ethics and trust laws that will guide some of your prohibited transactions, things that you don't want to do. So what are the consequences of a breach of fiduciary duty? So there's potential for personal liability. However, as trustees of a public pension system, basically, there's generally some governmental immunity and discretionary authority. Sometimes we'll overlay any questions about that, unless your breach is egregious and rises from self-dealing, and that's not that. I mean, that's, again, you're breaching the duty of loyalty when you do that, so that's something that is a consequence we do want for any trustees who may do that. And these are, some of the ways that you can, recourse is to make sure that the plan is made whole again, and we don't help trustees who breach those duties with any of their legal fees. So I would say, more importantly, to know how to limit your fiduciary liability is taking this fiduciary duty training, right? Know what your fiduciary duties are. Be a good steward of the trust funds and make sure you understand Number one, that duty of loyalty. That's going to inform all of your decisions. There is insurance. The plans cannot pay for it because that would be against their own self-interest, right? That wouldn't be okay, but often the plan sponsor, if there's a clear employer, they can pay for it. Sometimes there could be riders that the trustees themselves can pay for add on to D&O insurance. So that is possible. And I have seen those not be too pricey, so. And finally, I think I did mention that there is co-fiduciary liability if another trustee, if they're acting in a way that breaches their fiduciary responsibilities, and you either can help them conceal it or know about it and do nothing about it. So those are the items that you need to know, sort of just to be aware of, to be careful in case you see that behavior. So I made it through that in a pretty quick time, so I have a little bit of time for questions, if anyone has questions. And I know there were also a couple of questions in the event app. I don't know if anyone is interested in going to those, but if people have questions here, I'm happy to take them. So someone asked in the app what is some of the more difficult issues facing trustees in the current years, in the last 5 to 10 years. And I'm curious what your thoughts are on it. I'm happy to give my thoughts, but I'm curious if anyone else wants to talk about what they see as their more difficult issues these past couple years. No? Okay. Honestly, I think the political climate has always been a little difficult for public pension systems. There's a little bit of pension envy out there, and there's the political issues are now getting a little bit more fingers into the sauce, right? They're trying to get more involved in how you make decisions and reaching into issues that are fiduciary duty of the trustees, and that gets complicated. The other issue that I think is difficult these days and that a lot of trustees are not aware of is technology issues. And I think making sure that you're getting at minimum an annual report on the status of your technology and data protection and cybersecurity for your data and the funds that you manage, those are extremely important. And one of the highest risk areas is third-party vendor risks, because that is where you hear all of the breaches occurring, right, in the news. We hear it's always a third-party vendor that causes airports and airplanes to shut down. It causes, mass issues across the world from CrowdStrike. I can remember all the way back to Target days. That's when Target was first breached. It was something like a vendor to one of the air condition, I think it was an air conditioning system, or to some system, and the cyber hackers were able to get in that way. So third-party vendor risks are huge, and it's important that trustees be informed. So I would say that's one of to me, the biggest worries that I have, that fiduciaries, you know the investments are high risk, but are you aware of the risks of data privacy and protection? So, any other questions? I can let us go 5 minutes early. I didn't realize I had an extra 5 minutes.
Great.